Good morning, or I guess it's afternoon now, where I'm at. Welcome to our presentation today. We're going to be talking about the proposed changes to the Stark Law, the Anti-Kickback Statute, and the Civil Monetary Penalties Law. I'm Kim Stanger. I'm the head of the firm's Health Law Group, and we appreciate your participation today. This presentation today arises out of the government's push to try to streamline the regulations and the like as part of its sprint to coordinated care. On October 17, 2019, the government issued these proposed changes to the Anti-Kickback Statute, the Ethics and Patient Referrals Act, and the Civil Monetary Penalties Law. It was primarily designed to allow for certain types of value-based purchasing arrangements or coordinated care arrangements, but in the course of doing that, they also made significant changes, particularly to the Stark Law. The commentary is available there. I've given you the websites or the links or the citations so that you can access those if you would like. Those comments are due December 31st, 2019, and the actual final rules, whatever they may be, will issue sometimes after that. Because these are proposed rules, I'm actually going to go through them relatively quickly. When the final rules come out, we can pay more attention to them. But in the meantime, I think it's important for you to understand that these proposed rules are pending and maybe what they signal. The commentary is helpful not only concerning the proposed rules, but it also gives you insight into particularly CMS view of the enforcement and their interpretation of even existing provisions that aren't necessarily affected by the proposed rules. To that end, I'm going to focus on what I consider to be the most important changes. I'm not going to go through every single technical change that might be out there. In addition, along with that, just remember that I'm not covering the rules as they exist now. It's just focusing on the proposed changes. With that said, let's start with the Anti-Kickback Statute. The Anti-Kickback Statute, as you know, is a federal criminal statute that says you cannot knowingly and willfully offer, pay, solicit, or receive remuneration to induce referrals for items or services covered by government healthcare programs unless you structure that transaction to fit within a regulatory safe harbor. If you violate the Anti-Kickback Statute, a lot of bad stuff can happen to you. The key there is to make sure that you try to structure your deal to fit within an appropriate regulatory safe harbor. In the proposed rules, they've proposed two new regulatory, well, actually more than that, but they proposed new regulatory safe harbors, some affecting value-based purchasing arrangements, and another safe harbor dealing with the outcome-based services safe harbor. To comply with this new safe harbor for outcomes-based payment arrangements, it actually modifies the personal services arrangement to now, if you've got a contract with a particular physician or other entity for personal services, you can now structure that deal to accommodate certain outcome-based services. To fit within this safe harbor, the outcome-based payment arrangements have to improve quality of care and or reduce the costs while improving or maintaining quality of care. They have to be based on clinical evidence or credible medical support. The payment methodology has to be set in advance, be commercially reasonable and consistent with fair market value, and can't be based on the volume and value of referrals or other business payable by federal healthcare programs. The agreement does not create an incentive or can't create an incentive to act against the patient's best interest, so it couldn't incentivize them to limit medically necessary items or services. The agreement has to be for at least 1 year. It has to be written in writing specifying the required terms, and it has to incorporate policies to immediately address deficiencies in the quality of care. The OIG has proposed a number of safe harbors, all dealing with value-based arrangement situations, depending on the particular type. There's actually several of those. I'm going to talk about them just briefly, but all of them kind of turn on this whole concept of value-based care, value-based arrangements. The definitions in the safe harbors under the Anti-Kickback Statute are identical or very similar to those that exist for the new Stark safe harbors. They're all really geared towards making sure that the arrangement has a value-based purpose, meaning that it's designed to coordinate and manage the care of a target patient population that improves quality of care for a target patient population It appropriately reduces the cost to or growth in expenditures or payers without reducing the quality of care for a target patient population, or that it is designed to transition from healthcare delivery in a payment model that's based on a fee-for-service, volume to a quality of care and control of costs for a target patient population. So these proposals, the safe harbors, are designed to protect these types of programs that have those goals. The regulations refer to value-based enterprises, the new VBE. These are the parties to the value-based enterprise that would be established. The value-based enterprises have to be engaged in value-based activities, and they have to establish a value-based arrangement designed for a particular target population. The first of the safe harbors is the safe harbor for care coordination. This applies if you've got a value-based arrangement using evidence-based measures that advance coordination management of the target patient population. In order to fit within the safe harbor, the arrangement has to be commercially reasonable, has to be a written agreement that specifies the terms of the agreement. The remuneration that's provided has to be provided in kind and used to promote value-based activities. It does not can induce medically unnecessary services or reduce or limit services, and it can't be funded by outside third parties. It has to be funded by the parties to the actual value-based arrangement. The arrangement cannot be based on the referrals, or the business is not covered by, it can be based on referrals for services that are outside the value-based arrangement. And the recipient has to contribute to the remuneration that's involved. In addition, the arrangement cannot limit the provider's ability to make decisions in the best interest of the patient or require referrals to a particular provider if the patient wants to go someplace else or the payer determines the particular provider. And you can't include marketing or marketing to the patients or patient recruitment activities as a way to kind of bolster your practice by using this as a way to do that. It's got to have certain terms that require monitoring and reporting of the performance of the value-based enterprise. And it's got to have the ability to terminate the arrangement within 60 days if the value-based enterprise's accountable body, the governing body, determines that it's simply not working. The remuneration cannot be diverted, resold, or used for an unlawful purpose, and the value-based enterprise has to make information available to HHS upon request. That's the first of the safe harbors. The next safe harbor is a value-based arrangement. There's actually several value-based arrangements. The requirements differ depending on how much risk is involved. Under the first one, it applies to substantial downside risk if the value-based enterprise has or will assume in the next 6 months substantial downside financial risk that's defined in as defined in the regulations. The value-based enterprise participants have to share in that risk. The payments between the value-based enterprise and its participants have to be used for the value-based activities and purposes and can't limit medically necessary items or services. It can't take into account the referrals, and they have to satisfy certain other conditions associated with that. The writing has to be, the arrangement has to be set out in writing, setting forth the terms in advance. It can't be used to induce or limit participants' ability to make decisions that are in the best interest of the patient. So the physician, the providers always have to have the right to make the decisions that they feel are in the best interest of the patient. And you've got to make the records available to HHS upon request. There's a separate safe harbor that applies to value-based arrangements that carry full financial risk. They apply if the value-based enterprise has or is going to assume in the next 6 months full financial risk for the cost of providing care for at least 1 year, cost of providing care for those in the target patient population. The writing has to be signed by the parties specifying the terms. The payments between the value-based entity or enterprise and the participants can't be used or have to be used for the value-based activities and purposes. They can't limit medically necessary items or services. They can't take into account referrals, and they have to satisfy certain other conditions. The value-based enterprise has to provide certain quality assurance measures built into this arrangement. They can't use it to market or recruit patients. They've got to make the records available to HHS upon request, and there are certain other requirements that have to be satisfied. There's a separate safe harbor for arrangements for patient engagement, quality, outcomes, or efficiencies. This allows a provider to provide certain patient engagement tools or support that are furnished by the provider and the value-based enterprise directly to the patient. In order to fit within the safe harbor, the value-based enterprise participant has to provide those tools or support. They can't be funded by outsiders. It only applies to in-kind tools or support that furthers the specific health-related goals, not cash or cash equivalents. You can't just subsidize it, but you can provide these items or support like ongoing monitor, preventative services, things like that. That item can't be diverted, sold, or used improperly, or at least the value-based enterprise participant can't have knowledge that it's going to be used improperly. And the aggregate retail value of those tools or support have to be less than or equal to $500 per year. You've got to make the records available to HHS upon request if they want to come in there and check on you. There's a safe harbor for participating in certain CMS-sponsored programs. Generally, you just need to make sure that you're complying with the terms of that program, and none of the terms of the program induce ordering of medically unnecessary services or reduce the ordering of or discourage the ordering of medically necessary services. Both the Stark and the anti-kickback safe harbors have been extended to certain cybersecurity support that is provided. Under this safe harbor, under the anti-kickback statute, you can provide certain items of technology or services that are non-monetary, so you can't simply fund it, but you could provide technology services or items if their use is predominantly for cybersecurity. It could have related uses so long as the use is primarily for cybersecurity. You can't provide the hardware. You can provide the software or other items of support. That donation has to be made in a situation where the donor does not take into account the referrals when determining either the eligibility, the amount of support that you're going to give, or the nature of the tech or services that you're provided. And you can't condition that donation on the referral. So from the donor's perspective, they can't give this based on referrals. Similarly, from the recipient's point of view, they can't make the donation a condition of doing business. So they can't go, for example, a physician's office couldn't go to the hospital and say, hey, we're not going to do business with you unless you provide these services to you. The parties have got to have a written signed agreement that describes the tech and the services that is actually going to be provided. And if the recipient is going to be expected to make a contribution, it's got to specify the contribution. Now, importantly, that doesn't require the recipient to make the contribution, unlike other EHR safe harbors. So that could be an important factor. And the donor does not shift the cost to any federal program on its cost reports or the like. There's another safe harbor that applies to incentive payments made by an ACO to an assigned beneficiary under a beneficiary incentive program that's established by CMS. You just got to make sure that you comply with the terms of those programs. All right, those are the new safe harbors that are available under the anti-kickback statute. In addition, the OIG tweaked some of the existing safe harbors. Perhaps most importantly, they tweaked some of the requirements under the personal services safe harbor. This is the one that you normally want to rely on if you're entering into an independent contractor arrangement with a referral entity. It used to be that if that contractor was going to provide services on a periodic or sporadic basis, that they had to specify the exact times that those services were going to be provided. Under the proposed rule, the OIG would remove that requirement, so you're not required to specify the schedule for periodic services arrangements. In addition, under the existing rule, it's not enough that you specify the compensation formula in advance. You've got to actually specify or identify the aggregate compensation in advance. Under the proposed rule, they would modify that, so similar to Stark, you only have to specify the compensation methodology in advance, not necessarily the aggregate compensation. It's enough if you just specify the compensation methodology in advance. They've modified the EHR support safe harbor that allows entities to donate certain items or services for EHR. It now includes cybersecurity software or services. This is separate and apart from the separate safe harbor that is directly geared towards cybersecurity tech or support. Under the new safe harbor, or under the existing safe harbor for EHR support, it can now include cybersecurity software services. In addition, the EHR donor does not have to engage, or in order to do it, they've clarified that the EHA donor cannot engage in information blocking regarding the donated items or services, and the beneficiary may have the equivalent items or services. You could still go ahead and provide these new services. They've expanded the scope of the local transportation safe harbor. This is the safe harbor that allows healthcare entities, for example, to send out a regular shuttle bus to pick up patients or to make other arrangements for local transportation. They've tightened or loosened the reins a little bit to make it more accessible to people, particularly in rural areas. They've extended the mileage limit now for rural patients, so it extends to up to 75 miles, that you could have this program bringing in patients for up to 75 miles. There is no mileage limit if the patient is being discharged from an inpatient facility and transported to the patient's residence or another residence after their care or treatment. The new proposed revisions to the safe harbor contain additional definitions that were previously undefined in the current version, including definitions of the eligible entity, established penalties, the shuttle service, the urban area, and rural areas. There were significant changes to the warranty safe harbor. I'm not going to go through all of those because a lot of you don't use that very often and they're pretty technical. So let's move on to the big ticket, which is the Stark exception. Under the Ethics and Patient Referrals Act, or Stark, it basically says, for those of you who may not know, that if a physician or a member of the physician's family has a financial relationship with an entity, that physician can't make referrals to that provider of certain designated health services for these certain designated health services. And if they do make improper referrals, that entity cannot bill Medicare or Medicaid for, or at least arguably Medicaid, for such designated health services unless you've structured to fit the arrangement to fit within a regulatory exception. If you fail to structure the deal appropriately, then you can be subject to all sorts of penalties, including repayment obligations and the like. The new proposed rules have significant changes to the, we propose significant changes to the Stark regulations. We'll go through some of those. One of the things that's interesting is they've removed the period of disallowance. Under the current regulations, they define the period that you cannot bill for services that were provided by an improper referral from the time that there is noncompliance until you actually cure that noncompliance, and to the extent you've made overpayments or underpayments, that you get those payments back. So it kind of extended the period of disallowance, the penalty provisions for, it could be an indefinite period of time. In the commentary, they basically said that that period of disallowance really wasn't workable and it was impractical, and therefore they're, at least in the commentary, they're stating that you evaluate the time when the violation, the Stark violation, ends based on the circumstances of any particular case, and so it will be determined on a case-by-case basis. Interestingly, they did note, not surprisingly, that you can't simply cure the situation after the fact by go back and retroactively making payments or the like. That still, if there's noncompliance, there was noncompliance, and you've got to do the self-reports or the repayments, and you can't just cure it retroactively. They modified the definition of physician. Stark only applies to referrals by physicians or members of physicians or financial relationships with physicians or members of the physician's family. They've modified the definition of physician. It's basically the same persons, but they've added the additional conditions that are set forth in the Social Security Act. So it only applies to physicians who are legally authorized and practice within the scope of their licensure in the relevant state. Perhaps one of the most significant changes is the definition of designated health services. In the commentary and the definition, it appears that they have confirmed that Stark only applies to services, designated health services that are payable by Medicare, not Medicaid. A lot of people, a lot of regulators had believed that because some of the statutory changes, the Stark applies not only to referrals for designated health services payable by Medicare, but also Medicaid. But it appears that in the these proposed rules, at least, that they clarify that that's not the case. The STARC only applies to designated health services that are payable by Medicare. If so, that would be a significant issue, especially when it comes to repayment issues. So we want to certainly watch that. In addition, they've clarified that designated health services do not include services that are furnished to inpatients by a hospital. If the furnishing of the services does not affect the amount of Medicare's payment to the hospital under the IPPS. This is a significant issue when it comes to, for example, repayment issues. I've had some clients that we've helped them with self-disclosures, and there have been referrals that have made. For example, maybe the referring physician refers somebody into the hospital. That hospital is paid under the IPPS, and even though the physician made the initial referral, then everything that takes place after that, are referred by other providers, but all of it's covered under the IPPS. And the argument was, well, why in the world should we have to repay everything just because that initial referral was made by the physician who has a prohibited STARC referral? In this particular clarification from the CMS, this would help us because it would exclude from DHS those services that are payable under the IPPS, as long as the referral did not affect the amount of Medicare's payment to the hospital under the IPPS. That is a very significant change and potentially very helpful. They've also clarified that STARC applies to ownership or investment interests, but STARC won't apply if the ownership or investment interest really doesn't have a functional, it doesn't result in any value or any income coming back to the affected physician. Specifically, they've modified the definition for ownership and investment interest so that they don't include titular ownership or investment without the ability or right to receive financial benefits or ownership of the investment. For example, you may have title, you may be technically an owner, but you're not getting any of the financial benefits out of the relationship. In that situation, they said STARC won't apply. In addition, if your only interest arises through an employee stock ownership plan, then that will not trigger STARC. They also modified or clarified the definition of fair market value in the proposed rules. As defined now, the general definition for fair market value is the value in an arm's length transaction with like parties and under like circumstances of like assets or services consistent with the general market value of the subject transaction. They incorporate the definition of general market value, which is defined as the price that items would bring as a result of bona fide bargaining at the time of the agreement. The net result of this, both for the general definition and the specific definitions when it comes to rental of space or equipment, is that now we're going to look at volume or value to the parties themselves, not necessarily some kind of generic version out there. It allows us to incorporate an element of these particular parties. What's the volume or value, or excuse me, what's the fair market value to these particular parties? That will give us more certainty in evaluating fair market value. It aligns more with the industry standard for those who do valuations and should be a helpful clarification. They also gave us a definition of commercially reasonable. A lot of the safe harbors under STARC require that the transaction be commercially reasonable. Under this definition now in the proposed rule, commercially reasonable means that the arrangement furthers a legitimate business purpose of the parties and is on similar terms and conditions as like arrangements. They specifically confirm that an arrangement may be commercially reasonable even if it does not result in a profit for one or more of the parties. This is important because some of the court cases that have come out there, they've used the fact that the hospital was losing money on a particular transaction as evidence that it was not commercially reasonable, and therefore it may result in a STARC law violation. This clarification confirms that certain types of transactions may be commercially reasonable even if you're losing money. For example, maybe your hospital ER, you've got a service line in the hospital that is losing money, but you need to continue to provide that in your community because the community needs it. Or maybe you're losing money because you've got to comply with EMTALA or other regulatory requirements. This new definition will be helpful in avoiding some of those unfortunate court cases out there where they've taken a different view of commercial reasonableness. Now, you still need to make sure in the commentary they confirm that commercially reasonable still confirms that you can't take into account the volume or value of referrals, and they confirm that a transaction is not commercially reasonable if it's illegal or duplicative. They also clarified the definition of volume or value of referrals. Generally, throughout the safe harbors, a lot of those safe harbors condition the arrangement that it can't be based on the volume or value of referrals. They usually say something to the effect that it can't directly or indirectly be based on the volume or value of referrals. In the proposed rules, they've taken out the reference to directly or indirectly, but in the commentary they confirmed that that's still a part of volume or value of referrals. But they've come up with kind of a bright line test or almost a mathematical formula for determining now whether or not a transaction varies with the volume or value of referrals. So under the new definition, if you're talking about a compensation arrangement where the compensation is paid by the entity to the physician or a member of the physician's family, the transaction, the compensation, is deemed to take into account the volume or value of referrals only if the formula is used to calculate the compensation includes the physician's referrals to that entity as a variable, resulting in an increase or decrease in the compensation that positively correlates with the number or value of the physician's referrals, or if there is a predetermined direct correlation between the physician's prior referrals to the entity and the prospective rate of compensation to be paid over the entire duration of the arrangement for which the compensation is to be determined. There's a similar definition for those situations where the physician's making payment to the entity. The benefit here is it gives us kind of a black and white rule, or what is intended to be kind of a black and white rule for determining whether or not a transaction implicates the volume or value of referrals. This is important because in some of the cases that have come out, the courts have looked at some of the transactions and concluded that because the hospital, for example, would not have entered this arrangement with the physician, then even if the arrangement was otherwise structured to fit within a regulatory safe harbor, because the hospital took into account the referrals when they were entering into that arrangement, the courts had said, well, then it was based on the volume and value of referrals because it was all conditioned on or predicated on the fact that they were going to be providing referrals. This new definition eliminates that type of analysis. Now you've got kind of a mathematical formula for determining whether or not the transaction really does affect the volume or value of referrals. This should be very helpful and very important in evaluating your transactions. All right, let's talk about some of the new safe harbors they've come out with. I think one that's going to be very helpful for all of us is they've got a new safe harbor that applies if you're paying remuneration to a physician for items or services that are provided by a physician that do not exceed $3,500 per calendar year. So it's kind of this blanket, very broad one. If you've just kind of got this small transaction, you made you had a technical snafu and you didn't have structure to fit within like the lease safe harbor, or you never got around to getting the writing for or you forgot to get the writing for a personal services safe harbor. Well, you've now got this new safe harbor that may apply. In order to get the benefit of it, the compensation cannot be determined in any manner that takes into account the volume or value of referrals. The compensation cannot exceed $3,500 per calendar year. That's subject to an annual CPI adjustment. The compensation can't exceed fair market value. The arrangement has to be commercially reasonable, and the compensation, if the compensation is for the use of space, equipment, personnel items, or supplies or services, then generally that compensation can't be based on the revenue that's attributable to such use, and you can't give a per unit of service fee or other arrangement, kind of like under the lease safe harbor, if the more referrals that the lessor or the person who's allowing the physician to use the space, if they don't affect the amount of the compensation by making more referrals and therefore receiving more money through this compensation formula, then in that situation, you can structure the deal to fit within this new safe harbor. This can be very helpful for addressing those types of situations where there were just kind of technical deficiencies along the way. Maybe you didn't get the lease in writing. Maybe you didn't get around to signing the agreement for a particular type of service, or you didn't think about it. Well, as long as that you haven't paid out, the value is not more than $3,500, you can use this new safe harbor to cure your deficiency, and then either enter into a new agreement going forward after that. So we hope that this one is actually going to make it into the final rule. Like the anti-kickback statute, Stark has proposed a bunch of new value-based arrangements with safe harbors. They incorporate the same type of definitions that were used in the anti-kickback statute. As with the anti-kickback statute, there's a Stark safe harbor that applies to value-based arrangements where the participants have full financial risk. The requirements are similar to that that's set forth in the anti-kickback safe harbor. Among other things, the remuneration has to be for value-based activities. It cannot induce the reduction of medically necessary items or services, and it can't be conditioned on referrals of patients who are not part of the value-based arrangement. And the records of the arrangement must be kept for at least 6 years. There's a similar safe harbor that applies to downside financial risks. This safe harbor applies if a physician has a meaningful downside risk for the failure to meet the value-based purposes of the value-based enterprise as defined in the regulations. That generally means that the physician has to be responsible to pay no less than 25% of the remuneration, or is financially responsible on a prospective basis for costs of the defined set of patient care items or services. The writing has to set forth the nature and extent of the risk, and the remuneration methodology has to be set in advance. The remuneration has to be used for value-based activities. It cannot induce the reduction of medically necessary items or services, and it can't be conditioned on referrals who are not part of the value-based arrangement. And again, you've got to keep records of the arrangement for 6 years. There's a general value-based arrangement safe harbor. It applies if the writing is signed by the parties, and that writing covers the value-based activities to be performed, how the value-based activities will further the value-based purposes, the target patient population, the type or nature of the remuneration, the methodology for the remuneration is set in advance, and the performance or quality standards are set in advance in that writing. The remuneration has to, again, be used for value-based activities, cannot induce the reduction of medically necessary items or services, and it cannot be conditioned on referrals of the patients who are not part of the value-based arrangement. You've got to maintain those records for, again, at least 6 years. Like the anti-kickback statute, they've created a new cybersecurity donation safe harbor. Like the anti-kickback statute, it pretty much parallels it. It only applies to non-monetary services, software, or information technology other than hardware, so you can't just give hardware. It has to be necessary and used predominantly for cybersecurity purposes. The eligibility, amount, and nature of the services cannot be determined based on referrals, so you don't just give these to your good referral sources. And the physician does not make the tech or services a condition of doing business. It's all got to be documented in a written agreement that's signed by the parties. As with the anti-kickback safe harbor, they also modified the Stark EHR donation safe harbor to extend to cybersecurity issues. They also confirmed that this would propose, under the proposed rule, that you can't have any kind of information blocking as part of that donation. And it used to be that the existing safe harbor had a December 31st, 2021 sunset provision, but that has been eliminated. So this will be around for a while, assuming that it's passed. They modified the fair market value safe harbor. The fair market value safe harbor is one of my favorite safe harbors. You can use it for covering things like equipment leases for physician services and the like. They've extended it now so that it applies to, or can be used to apply to the use of office space. If they are going to use it for office space, you got to make sure that the compensation cannot be based on a percentage of revenue that's attributable to services performed or generated through the use of that space. They've expanded or clarified the safe harbor that is out there, but is quite often it's overlooked or not used. This safe harbor applies to payments by a physician or a member of the physician's family to an entity as compensation for any items or services so long as that compensation is furnished at a price that's consistent with fair market value and there's not a safe harbor that's applicable. When they made these changes, the original safe harbor was actually broader. It would not apply if other safe harbors, for example, in .355 were available. Under the new safe harbor, they've ratcheted back that a little bit so that if that compensation arrangement, if one of the other safe harbors for leases, employment, or personal services arrangements, recruitment, isolated transaction, or group practice arrangements, if those safe harbors are applicable, then you can't rely on this safe harbor. On the other hand, if those aren't applicable, then this safe harbor in .357I would allow you to perhaps structure your arrangements if the payments are going to be made by a physician or a member of the physician's family. There was, for a long time, Stark has had an exception that applies to remuneration that's unrelated to designated health services, but that was interpreted so narrowly that it really was of no benefit or no use. And the proposed rules have tweaked that or revised that so that it may become a significant safe harbor that you may consider using out there. As proposed, the safe harbor would apply to remuneration provided by a hospital to a physician if the remuneration is unrelated to the provision of DHS, but they've defined what that means, what unrelated to the provision of DHS means. That means that the remuneration is not determined in a manner that takes into account the volume or value of the physician's referrals, and the remuneration is for an item or services that is not related to the provision of patient care services. That, in turn, means that patient care services, or if it's related to patient care services, that means that the item, supply, device, or equipment or space are used in the diagnosis or treatment of a patient, and any tech that's provided is used to communicate with the patients regarding the patient care services. It does not mean services that could be provided by a person who is not a licensed medical professional. Those are deemed not to be related to the provision of patient services. So what does this mean? This means that it's possible for hospitals to enter into support agreements with physicians where they're providing items or services, so long as they're not like clinical items or services, maybe providing some kind of administrative support and other things like that. We'll certainly want to watch this, but this could become a potentially important tool for you in structuring your arrangements, particularly if it's arrangements in value-based care arrangements and those types of situations. They tweaked the current safe harbors for leases of space and equipment. Under the current safe harbors, those required that during that period of exclusivity, or during the period of the lease, that the lease space or equipment had to be used exclusively by the lessee. That created some problems because a lot of those leases are not done on an exclusive basis. Under the new proposed rule, exclusive use means that the lessee uses the lease space or equipment to the exclusion of the lessor or any person or entity related to the lessor. The lessor or any person or entity related to the lessor may not be an active or an invitee of the lessee to use the space or equipment. Now, the flip side of that means that it only has to be exclusive as to the lessor or the lessor's personnel. It does not have to be exclusive to other lessees. So it appears that under the new revisions, that the lessor could lease the space to several different lessees, and it doesn't have to be exclusive among those lessees, as between those lessees. If that's the case, then that could dramatically expand the potential situations where these leases could be used. They modified the physician recruitment safe harbor. It used to be under the existing rule, or it is under the existing rule, that if you're going to do a joint recruitment arrangement between a hospital and a physician group, that physician group has to sign that recruitment agreement. Now, under the proposed rule, that physician group only has to sign the agreement if the money's not going to flow through them directly to the recruited physician. So, under the new proposed rule, if it's going to be used to recruit a physician in the group, you only need to have the practice sign the recruitment agreement if the remuneration is provided indirectly to the physician through payments made to the practice, and the practice does not pass directly through to the physician all of the remuneration for the hospital. So, for example, if it's a situation like you're doing an income guarantee, where there's going to be some offsets and things like that. You may still need to get the physician group to sign, but if all they're doing is just passing all the stuff directly through to the recruited physician, then the practice group doesn't have to sign that agreement. They modified the recruitment exception that applies to non-physician practitioners, or NPPs. They just tweaked this a little bit. Under the proposed rule, the recruitment agreement must be executed before the NPP enters into a compensation agreement with the physician or physician group. So you can't have an existing compensation agreement between the physician group and the NPP, and then after the fact enter into this recruitment agreement to subsidize those costs. The recruitment agreement has to be done either before or at the same time as the compensation arrangement. In addition, the physician or group must engage the NPP to provide direct patient care services, and that's defined in the regulation. The isolated transaction safe harbor, this isn't necessarily a favorable change, but the government wanted to clarify it. The isolated transaction safe harbor applies to, like it says, isolated transactions like the one-time sale of practice or something like that. They have confirmed that under the proposed rule that it applies if there's a single payment or an integrally related installment payments if the total aggregate payment fixed before the first payment is made and does not take into account the volume or value of referrals or otherwise generated by the physician, and the payments are immediately negotiable, guaranteed, secured by negotiable promissory note or the like. It does include the one-time sale of property, practice, etc., but not a single payment for multiple repeated services, such as a payment for services previously provided but not yet compensated. The bottom line there is, the reason that they put that in, is some people were arguing that they could go in there and cure past deficiencies by simply doing this isolated transaction, a one-time payment that supposedly wiped out the prior non-compliance. And in this modification to the isolated services agreement or isolated transaction safe harbor, the CMS confirmed that no, you can't do that. That's not what it was intended to do. They've also tweaked the group compensation rules. Under Stark, in order to qualify as a group practice, you've got to satisfy certain compensation structures. They've modified those structures, particularly with regard to the share of overall profits. So under the group practice compensation methodology, you can pay members of the group a share of the overall profits. But they've confirmed that if you're going to do that, what that means by overall profits. If the group has less than 5 physicians in the group, or 5 or less physicians in the group, then the overall profits mean the profits derived from DHS of the entire group. It wasn't entirely clear in the past, but they've now confirmed that. On the other hand, if the group has more than 5 physicians in the group, then you could decide to come up with subgroups, so long as, and divide the overall profits from DHS among those 5 members in that subgroup. But you've got to make sure that there's at least 5 members in the subgroup. They've confirmed also that if you're going to go that way, that you divide up all the profits from all the DHS within that group. There were certain people that were out there structuring group compensation arrangements where they would divide up different DHS among different groups. So you'd have this group of 5 that might have, DHS may be divided up for this particular service, but divided separately for a different type of DHS. And in the commentary, they confirmed, no, that's not what was intended. They also tweaked a little bit the group practice compensation structure for productivity bonuses. They just confirmed that you may pay the productivity bonus based on services that are not DHS, but also confirmed that it's the services that are not DHS or would not be DHS if it was payable by Medicare. They added a new methodology, a safe harbor methodology for those group practice exceptions. Under the group practice compensation structures, your compensation structure is deemed not to vary with the volume and value of referrals as long as you've satisfied certain criteria. They gave you the safe harbors for distribution of profits, overall profits. They give you safe harbors for productivity bonuses, and now they've added a new one. You may pay profits from DHS that are directly attributable to a physician's participation in a value-based enterprise as defined in 411.351. So it now facilitates the group's ability to enter into value-based enterprises and value-based arrangements. They tweaked the definitions for indirect compensation arrangements and confirmed that the only safe harbors applicable to indirect compensation arrangements are those exceptions that fit within .355 that are applicable to both ownership and compensation arrangements. An indirect compensation arrangement that fits within the specific safe harbor under 401.357 and value-based compensation arrangements per 401.357. So they've narrowed a little bit what they mean by indirect compensation arrangements and what you need to do to fit within those. They also clarified the rule that allows you to condition compensation on referrals. Under the special rules on productivity, Stark actually allows entities that have a professional services arrangement or an employment situation to require referrals between the entities so long as certain criteria are satisfied. They've tweaked those requirements a little bit, so now you may condition the physician's compensation in employment personal services arrangements or managed care contracts if you satisfy those conditions. And those conditions now also include that the compensation formula has to be set in advance for the duration of the arrangement, that any changes to the compensation or compensation formula must be made prospectively, and the compensation must be fair market value for the physician's services. Also, for all of those safe harbors that might particularly might implicate this, like the employment safe harbor, the professional services safe harbor, fair market value safe harbor, value-based arrangement safe harbors, those incorporate this language so that if you are going to condition referrals in those arrangements, then you need to make sure that those requirements are structured to fit within this requirement in 401.357D4 or 354D. They also tweaked the writing and signature requirement. A lot of the Stark safe harbors require that you have a written agreement that's signed by the parties. In the existing rule, they give you a grace period of up to 90 days to get that signature in place. So as long as you had the writing in place and you just failed to get the signature, you had up to 90 days to get that signature in place. They've now expanded that, so it not only applies if you failed to obtain the signature, it also applies if you failed to obtain the writing itself. So if you start this agreement, start this relationship, but you failed to have the written signed agreement in place, you've got up to 90 days to put that written signed agreement in place. That could be really helpful, especially if you're using this in conjunction with that $3,500 safe harbor. You might be able to avoid noncompliance in those situations. In a lot of the safe harbors, they made reference to the anti-kickback statute, that in order to fit within the safe harbor, you also had to make sure that you didn't violate the anti-kickback statute. They've taken out all of those references to the anti-kickback statute. You still have to comply with both, but it was kind of redundant to have that particular provision in the Stark rules. All right, that's a quick overview of the Stark law changes. Real quickly, in the civil monetary penalties law, that's a separate statute that's out there. Among other things, it prohibits offering remuneration to a Medicare or Medicaid beneficiary if you know or should know that that remuneration is likely to influence such beneficiary to order or receive services from a particular provider or supplier. In the proposed rule, they modified the definition of remuneration so that you can provide certain telehealth services to persons with end-stage renal disease as long as you satisfy certain criteria. All right, that is a brief overview of the proposed rules. We will be interested to see whether or not those proposals go through. There are other provisions. If you haven't read the proposed rules or the commentary, you may want to do so, because there are some provisions in there, some statements in there that give you insight into where CMS and the OIG is coming from, even if that the final rules or didn't make it into the final rules. It at least helps you evaluate your regulatory compliance. If you've got any questions concerning any of these things, you're not alone. Most of us do. But you're welcome to either submit questions using the chat feature or shoot me an email offline, and I'll try to respond as best I can based on the information that we've got. Thank you very much. Appreciate your participation today and hope you all have great holidays.